got a brace. No, I need to go get a shot. I already had 2 shots this year, so I've been kind of apprehensive about wanting to do that. Are you getting boxes anymore? Yeah. Okay, well, I'll bring you cheaper. Yeah, well, I had a friend of mine contact me and I told him, man, it's everybody said they didn't get that many, I didn't mess with those great matches started. I had a guy. So it's not as advanced as he goes. I had to split by the 3 times. I'm like, not there. He was getting the contract. Doing himself. Never get ready. Did you ever get married again? Well, I said, if I get divorced, I don't know why this on. I said, you start back to me, pack my bag, and tell me where we're going. I ain't doing it again. Been there, done that, I ain't doing it again. Did you see if I can send the hair? Sir, we can be really good here today. Sure.
Come on in here. How you doing?
Good, sir.
Good to see you, brother.
Good to see you. Good morning. You know, I'm ready around that class. It's much like you're saying, I got it. Does he think anything? We don't try to get you. They want to put us. Like that, that's what I mean. But if I've been or something. Then that, and I'm not going to go down that road line of Gordon's hands on. Right now, she said, "Go to March, some people put off some of the trees to that." That's why probably I'm on. Yeah, and he goes. Oh, far over there by the dress. Not saying because the camp, I'm around open. Uh-oh. He goes over in the field. No, I think we're into that.
I
think this is probably just talking more than.
Yeah.
They're not coming up.
No. Yeah.
I'm looking at the surveyors for the subdivision. We'll just put those where they can kind of. You're too nervous. I'm gonna let him have it all. Nobody's gonna be up here. No, he always shows up. He's a glutton. He's got a pretty lot. I didn't get my homework. Uh-oh.
I got one because they wanted to make sure I didn't talk about anything other than what's on paper.
Please don't talk about this.
There, it's a new thing, I tell you, she went into 2 weeks. It changed. They got a cat, but it's 65-year-old lady. Well, the adult 14.
I didn't even bring my phone. I said it's not over here now. It's cool. I next to the other day.
Yeah, I saw.
Rush, did you bring your coffee? I don't know, I'm still or not.
I'm coffee down.
She's headed up.
But he doesn't show up. Yeah, it might not be. It's finally, it's comments about it all.
She's
How often? You can't help it, being got my.
Oh, yeah. Hey, Bob.
Hey, how are y'all?
He's gonna play.
You doing okay?
Yeah.
Good.
So this man. We need about that stuff.
He'll be back at 10. It's 10. That's about. I've got about 4 minutes to tell. Yeah.
So then you say.
Yeah.
Okay,
Maybe.
Well, this is fast again.
and then you'll transfer it over to me?
I've already mentioned those.
Okay.
No.
You
heard what?
What I said. Official business.
Institutional day.
Was.
Oh, I think, I don't know, singing peace. That's what it was saying, he did come to that, yeah, he did come to that.
He went to the one out county we had, but the one that.
Oh, well, not fair.
Other than that, he was happy.
I don't care.
He didn't-
I don't want
Yes, ma'am. I'm Shadow Friend.
Yeah, I know you were. So are you involved in the personal?
Lots there.
Yes, sir. Yes, sir.
Well, that, yeah, but now I don't gotta watch football.
Would you read this thing over? Which one? The small one, service. So it's, one that dots the i's and crosses the tongues, share, and everybody else. You see, it's great. It's glad 5 years now. They don't know how to have 10.
Yeah.
Everything's got to be because it's other ones have to be planned. And I just asked Work about it, and that's what the state's on side. And I guess the new legislation.
I'm gonna try this.
All these.
It's not video. Let's see.
And there's one.
There we go.
And they're saying that the new legislation was, well, I know about that. All of it's. I see Boston, senior year, it's got.
Bob, can you see the screen?
Yes,
On my
sir.
computer? Okay, good deal.
Here, I was actually no nerve about that first.
Yeah, he was on here earlier and then got off and said he'll be back. So we're waiting on him to come back.
Oh, the state law? Yes.
November 21st, we done it. He and back in there.
But I think that let's say the city and the ETJ is got out of line. That's the rate up there. So long as, but then, and of course, you probably know all this, but neither, but also this stuff. State law, something, I was for all municipalities. And that's often lower than ETJ.
But you can remove it.
Okay. Oh, good. I can see the mouse.
Volunteer to be a close. Yeah. So the old. And patients look at it. I saw him waiting.
Well,
On that corner. I was wondering, yeah, I saw 12.
that is rare. That is rare.
August.
Pete Gates goes over on 1111. He raised some of them term loose a few years ago. They back to him.
Well, yeah. We turned it down.
about 2 weeks.
Yeah,
But there was somebody else that raised some over there and let something go, so there may be some residue of the building permit. Oh, it'd be nice.
You want me to go ahead and start me, even though he's not here?
Yeah, I heard it, and here we pops up, yeah.
9:05 and announce that we do have a quorum. All the commissioners are here. Do we have any public comments? All right, so our next item of business will be discuss subdivision guidelines and we get a pen. We're waiting on Bob Bass to rejoin us on Zoom to do that. And I got
Did everyone that was on my committee receive a copy of the updated rules and regulations that Mr. Bass had sent? Did you receive it?
the one that's on the screen.
Yeah. Okay, good deal. Also, Commissioner Pratt has two guests today that have to be somewhere else. Before this meeting is probably going to conclude, so. Chad, no, go ahead.
I've got Chris Means and Mike Jones here. They're developers in precinct 1. And they've been talking to me, working on building some RV parks, and they asked some good questions. And I thought this would be the perfect time to come ask the group. And so if y'all would like to ask your questions, we can kind of start off with that if you'd like.
I just got, just going over this, a lot of this is new, these RV parks in the county. And, showing it has to be engineered. And some of these, like detention ponds and things, I mean, I'm building around a 70-acre lake. I don't see a need for that, really, as far as grading, I mean, it all runs already to it. I don't want to build these paths and roads, so I might start trying to do that. That's $25,000 I can save right off the bat. It's already costly, and I mean, there's been some upgrades now. Instead of rock pads, it'll be concrete or asphalt. I'm okay with all that. If I can get this thing platted by surveyor, I mean, that's just, I guess my main concern is trying to get out of having to go through an engineer to do so. When it's all platted, the survey or the septic engineer's already looking at it, approved, tell me what I need. I don't see any other thing.
I think their question is, Brian said that you gotta have an engineer to engineer the drainage and everything on the property, and that's what they're trying to verify and find out about.
I have civil plans, I mean, I don't know that I need all that.
And so I was just asking, well, where's that in the policy? Is that part of the state code requirement, or is that something the county has added?
Yeah, we added it. It's in there. It's gotta be engineered. There's not a thing in there that this court can't waive. There's not a restriction in there that you can't come back to this court and ask for not a waive, a variance on it. But it's you.
And that's what we're asking for also. We're in the same boat here. We've already got 2 detention ponds, there's drop water runs directly to them. They're regulated, and we've already got it surveyed out, mapped out, approved everywhere, except they're asking for, engineer, okay, to go through there and we can put in a water detention system that we don't need.
Well, here's my take on it. There's just one person. It's not the court. But I'm not an engineer. You're not an engineer, and we've got to have somebody tell us that that's not needed. So I don't see how you're not going to have to go to at least pay an engineer a little bit, saying the lake is going to serve as our retention pond. You're going to have something come back to us because we can't wipe it out of the. In my opinion, we can't wipe it out of there because the next guy is going to need it. So we're going to have to do a variance, but you're going to have to prove to me that a variance is okay.
And I can verify the ponds were there, and the pre-existing natural drainage went to the ponds on there, went to the old city lake on his. But I can't verify that the new design is going to send the water that direction. I guess that's what they're saying.
Are you the one projects on the state right away?
No. Well,
Don't
just a
the
drop.
county already have an engineer, Abbott, that's hired to, y'all have hired to. That's who we're having to deal with.
That's-
Tell
Yeah,
them
he-
that we-
That's fine, you take it to him and he verifies that all that's good, that's good.
we- That's the problem we're at right now. Is he's telling us because it's private property and we have, and he's calling our RV spots a subdivision. And these ponds are just, everything drains down right to them. And it's already been platted out, everybody's come with it, or everything's okay, but he said that we still need a definitive pond because he's valuing it as two different pieces of property, and it's not two different pieces of property, it's one.
Well, and what it is on that, that's where I can vouch these ponds are here. The property that you actually platted for the RV park does not include the ponds.
No, it doesn't actually include the.
From his point of view, all he is seeing is this piece of property with no retention ponds. So that's where I'm saying I can verify the ponds are there to drain to, and to put a retention pond between the park and the pond, which ain't 100 yards apart, would be wasted. I agree with that. And that's one of the places where a variance comes into play. As far as just removing engineering from the overall subdivision policy, that won't come into play on this. And that's what Mr. Pearson was saying. You don't necessarily need to build a pond, but you might need an engineer to say that the changes you have made to the land is still going to ensure that the water runs to that pond.
Yeah, I mean, in my case, I couldn't make it go any other way.
And they're about the same way.
Is the pond, showing on the plat?
Yes, sir.
No, that's it. The pond's not on the plat.
Oh, okay, they're not on that subdivision, but they're on the.
It's on the adjoining property, which they own all of.
And Mr. Abbott is the one telling us that, I mean, we're dealing with him, and we've done everything he asked us to do. But this, I mean, I think this is just a point where we've got something that we don't need to, that's something that we really can't get.
That's,
Have you received anything from the engineering? Have you seen what? they-
I've been watching that talk back and forth with Mr. Jones.
Okay.
We ain't got too far into Mr. Means yet.
I don't know what this, the whole deal, but just listening to you talk is, in this case, you got a pond that's on an adjacent property, even though he owns that adjacent property. What we've discussed is, what Mr. Bass said, you know, we're doing these plats for these rentals. But would that pond not need some sort of easement, drainage easement or something like that? And that's what we've been told by these engineers is that they're going to tell us what they need for a drainage. Because in the future, if that piece that had that pond is sold to someone else and something was done, could you have a conflict? You know, or should that pond not be included as part of that plan?
That's what I was thinking. The
See,
pond
that's
should be-
the whole reason that this verbiage is in here, is for the engineers to tell us what needs to be done with water, because water is such a big issue.
Or at least an easement.
Yeah, that's what's, you know, been, that's what we've been discussed before, and that may be, and in this particular situation, maybe the variance would be is that there's an easement that incorporates all the pond, so that all that water can always go there if that's where it needs to go. But that's just what I'm hearing in this discussion.
Reason behind all this too is we don't want to pay commercial taxes on property we're not using commercial. You know, if it's your drainage, especially me, I've got 70 acres of water. But I'm not doing nothing, I'm already paying enough on it, so I don't want to include the whole thing, I don't mind my shoreline or whatever, and it is. Maybe something.
But an easement wouldn't,
Easement.
it could be a separate document.
Yeah.
Where it was an easement, then the easement would actually be incumbent on that land, not a part of that land to make it commercial, as you've seen.
Yeah,
So but that might be something that y'all can look at for a variance.
We've been dealing with a lot of the flood control lakes that were built way back in the 50s.
Mhm.
And when the federal government built those easements go for miles back upstream on the properties that lake's not owned by, but the easements go way back on the other property. So you're gonna probably have to do something like that. You're gonna have to show an easement on your platted piece of property showing that you've got an easement on that lake, saying it's okay for that water to go in there. And then that'll probably make Brian happy.
And if he's not wanting to change it to commercial, that portion for tax bases, like I said, it could be, wouldn't have to necessarily be on plat, it could be a separate document. Because I was seeing the tree top, there, so. Yeah, that's what I said, he actually.
Okay. That sounds good to me.
Yeah, try, if you would, try to work with, Mr. Abbott that way, and let's see if we can get it resolved.
Okay.
See if he,
But you work it out and then come back, you get with Chad, and he'll put it on the agenda for us to come in here and to discuss a variance on your situation.
Okay,
That's not on just y'all, that's on anybody putting in a subdivision.
yeah,
I mean, come back and tell us your situation.
Would it be a suggestion to go to Mr. Abbott with a proposed? If before you spend the money for the easement and having that done, propose that as
Yeah.
something he would recommend.
Yeah. Go to-
That's what y'all gonna wanna hear.
that's right, yeah.
We've been in conversation with Abbott and working back and forth, trying to find a resolution to this. Does that answer y'all questions over the engineering part, though, to verify where the water's going?
That's my biggest concern, yeah, I mean, I don't want.
that's same here, we don't wanna pay taxes, commercial taxes on ponds and stuff that we're not using for commercial use at all. And we've already got, I mean, I know we, in our case, I don't think Chris got that for you, but in our case, it's already all. The fire marshal's already approved all the septic system. Everything's done except the erosion and water retention system. And that's just, they gotta set us a halt right now, because we can't do nothing except, until we rectify that. And that's all, that's all we want to say.
Brian's out of town this week. He'll be back next Tuesday. I think he's still communicating through emails and phone calls. And we'll follow up from there with this and move on. Do you have any other questions related?
Yeah, just a second.
I got one. It's got to do with the variance. Let's say I got a 12-acre tract, I'm gonna divide it up into 3 tracts. I got road frontage and I got power lines in it. So I get it divided up and shipped over to the engineer. And the engineer, I've been talking to Abbott, and I talked to one of the people intended out to do the work. So if I divide this tract up into 3 tracts, and he's gonna sell all 3 of them, so that means it's gonna require subdivision, tier 2. Now then, do I take and once I submit it to Abbott, and let's say we want one little variance to before we finish the plan. Does that mean we submit a variance to our commissioner and then set up a time for the court, and then we gotta wait on the court to come back into session, and then we present the variance to the court, and then they approve it or reject it, and then I'm looking at the time thing. How long it's gonna take me to do this job. So if I'm gonna have to just tell the client that you want this one variance, we gotta wait till the next court hearing before we can even submit it. Or can I go to my commissioner, and my one commissioner of that precinct, can he do it himself, or do we gotta wait for the time to come back into court to ask y'all and get it approved? Used to, I could just go straight to the commissioner had the power to say, yeah, go ahead, that's just fine. Me and Virgil worked on many of them. I've always been able to come to Virgil and say, Virgil, look, this is what we got. Can we take and, do we gotta do this or something? This is crazy, what you're asking.
One commissioner outside of this court has absolutely no authority on those subdivision guidelines.
It's gotta go before the commission court. Now, some of the stuff we worked out has not been really a variance,
Yeah,
You
so,
know what I mean? It's not really a variance. But
Well-
something that really is a variance, like the gentleman back there, now that has to come to the court.
yeah,
But minor things that are not gonna affect anything, not gonna really affect the rules and regulations, that's really not variance. That's something you should work out with your commissioner. But if it entails a variance, like these gentlemen back here are gonna have, then we gotta come full.
Yeah, I didn't know, some minor things, we had to come back and wait 3 weeks or 4 till y'all have another hearing. To
You
come
need
back.
to have 2 weeks. You should never have to wait more than 2 weeks.
Y'all have one every 2 weeks?
Yes, sir.
Okay.
Well, and just to know, if you were asking for certain variances in Dallas County, you might, I think Jess would probably tell you, some of those are 9 months, year and a half in construction.
But they have a whole committee and there's a big process that's not here. We're talking about, and as Mr. Pearson said, 2 weeks. But really, the time frame shouldn't be that large.
You know, I didn't know exactly how long we had to wait.
But, now, one thing, and we discussed this, I think, at the last meeting. Do y'all have like a variant sheet or something now that you're giving to a client where it tells specifically what they're asking stuff? Or is it just gonna be, I'm gonna go have my client go to you and say, hey, I need to try to overlook this one particular portion of the ordinance and what I'm, and the project I'm trying to work on, and then you'll just bring it to them. I mean, would I instruct my client on how to do this variance process?
Currently, you get with your commissioner and explain the variance you want. He's the one that's got to bring it to the
Okay,
court.
so if I had a client in your district, he would go to you and then you would bring it, okay, that's all. I just need to tell my clients on how to address this if they want.
And as commissioner, would y'all rather have a form that's kind of standard that you decide what the variance is on, exactly what you're going to vary, the variance on that regulation, dated and signed and filed to the record?
I think that would be good.
That's what I, and in other areas, this is what they have, they have a variance form.
Well,
And you have the client come up and he says, this is what I'm requesting.
right,
And then it still goes through you to get to the court,
Right.
but at least you have something in writing
Right.
on what specifically they're asking.
Because those are usually probably put in your last minute, and if it's the standard form you're used to seeing,
right.
it's a lot easier to gauge what needs to be done versus having to spend extra time.
And I have one question, but I guess before we get off the rental RV thing, whatever. I didn't see, is there a fee? I had a client tell me that there's a fee now for individual campsites.
Yeah,
When
there
did that-
is.
When did we get?
That's always been there.
Is it in the ordinance? I didn't
Yes.
see it.
Yes,
Okay,
sir.
I just briefly looked over it, I
Yeah.
didn't see it.
But you wouldn't wanna do, if I was putting in a subdivision and I hired you as a surveyor and Brandon was the commissioner, I wouldn't wanna do something that I didn't have something showing that the court waived that, did a variance or something other, because otherwise 10 years from now, something comes up on somebody that bought that and they have an issue out there. In the world we live in, they're gonna come back and they're gonna sue the developer, and they're gonna sue that surveyor, and they're gonna sue that commissioner for doing something outside of that you didn't have the authority to do. And I don't know why anybody would wanna go out on that limb and without, they can't come back on this court.
Well, they really just little minor things we was taking care of.
Yes.
It wasn't taking care of major things,
Yes.
you're gonna get y'all sued, me sued, everybody else.
Right.
If it was, I wanted them paper inside my
That's-
phone,
Yes, sir.
and a signature on.
Yes.
I thought about little minor. I didn't know it was little minor things here to come in front of the
Well,
court.
just remember what's minor to you might not be minor to that future owner. That's all I'm saying, the world we
Well,
live in.
I understand that.
Yes.
After 40 years of service, I kind of know by now what's gonna affect the country and what have you.
Yes.
Was Bob coming on or what?
You got the wrong date.
No, he was here
He
earlier.
was here earlier, said he was coming back on. I asked.
Let me call him.
Jim, I thank y'all for coming, man.
Okay.
Y'all are welcome to stay for the rest of the workshop if y'all have other engagements. If we've answered your questions, you're free to go.
Yes, sir.
Hey, Red, how you doing? Fine, fine. We're waiting for Mr. Bass to get on the Zoom with us. Well, yeah. All right. Yes. We're waiting. We're waiting. We're ready in the court. We're ready to get on the Zoom with you. Well, okay. He said we hadn't joined, so. We better get Scott in here.
He may have used the link that you sent him, and he should use the link that Scott sent him this morning.
Okay. Do you see a link that our IT person Scott sent you this morning? Link up with us and we're ready to get started.
He's sending it to him right now.
Thank you. All right, he's got it.
Yes.
I got one more question. If we, we were talking about, talking to Mr. Abbott about getting an easement, an easement to the ponds and all that. Can he make the final decision, or are we gonna have to have another engineer, okay, his engineer?
All Mr. Abbott does is review that it matches our subdivision policy, and when he sends something back to you, it's where it's out of alignment with our policy. That's what he references. He can't actually do engineering for you. He can just tell you, this is where you're out of the bounds of the subdivision policy or the other part.
Okay. But if he okays all that, then it'll be okay with y'all.
If he's gonna do the letter, yes, sir. If he
It's
sends,
enough for y'all to say, okay, yes, a variance will be granted or no, it won't.
he can't say a variance will not be granted, only the court can, but what he.
Say y'all, you said.
Okay.
Well, can I ask one question?
Hold on, Mr. Bass, can you hear us?
I can. How are you all?
All right, very good.
Let's move on back.
Mr. Bass, would you go over the rules change that you've made in the subdivision that you submitted to us that the state now requires? Could you briefly go over the one you're looking? Do you see this? What we are looking at now, Mr. Bass?
Yeah. Hang on.
The markup document.
I'm viewing Judge Andy Reese's screen, and he's got the introduction paragraph pulled up.
Okay, that is the last revised edition that you've sent us.
Okay.
So we would, if you could go over that briefly, and then we'll have some questions after that.
All right. Primarily, the last legislative session kind of worked a number on counties. The previous understanding that we've operated under for several years has been that any subdivision that had interior roads was subject to regulation. Well, in the last session, the legislature had basically two versions of One was a Senate version, one was a House version. They both passed their respective houses, but had to go to committee. The Senate version was much more restrictive, even beyond what has happened. So what came out of committee was sort of a compromise, but what they did is they went into, if you'll pull down on that page that's on the screen now, to section 1.3. It's on page 7.
Okay.
That's eight.
Eight. All right.
Hey,
Section 1.3,
general exceptions to these regulations.
correct.
Okay.
So in that section, the legislature took out the portion that was where a portion of a street is dedicated not just to the public, but also for the use of purchasers or owners of lots fronting on or adjacent to streets, alleys, squares, parks, or other parts of the tract. That was stricken. And so that created a problem, or has created a problem, in the way that if you read that initially, it looks like they've taken out private streets altogether. Now, for all but the exceptions that are laid out in 1.3, the definition of the subdivision, if you'll go up a little more, to paragraph 1.1, okay, there you will see these regulations apply to any subdivision of land in Van Zandt County which divides the tract into 2 or more parts. So that's virtually any division. A subdivision of the tract, including an addition, or lots. And then it goes on to say, or streets, alleys, parks, other parts of the tract intended to be dedicated to public use. So trying to come to grips with that, I think it means that any subdivision of land less than 10 plus acres would still fall under the regulations, even if it's not dedicated to the public, but it is a subdivision, and they do divide the tract into lots. So at least that's the way we think it works. And then you go back to the exceptions, and in those cases, that's where if the owner of the tract, the first one is it continues to be used for agricultural purposes. The second one, a division of land into family tracts, is exempt if the division is into 4 or fewer parts and the subdivision tract does not lay out streets. The third one is a division of land to rural home tracts is exempt if all of the acres are more than 10 acres in area, and the owner does not lay out any part of the tract, streets, alleys, parks, or other parts of the tract. Then there's an exemption there, and then there's later an exemption for the division of tract into veterans tracts if all of the tracts are to be sold to veterans. So when you really boil it down, we think that the 10+ acres may be where most of the problems will arise, and it's clearly exempt. You can't regulate it. It's not, I don't know that it's subject to regulation. Now, that's the way the legislature apparently has ruled. Some counties are attempting to retain that authority by naming the fire, I say some authority, they've limited themselves to just inspecting the roads in such a 10+ acre tract, and thereby and delegate that duty of inspection to the fire marshal, for example, or some other person authorized to enforce the ordinance to determine whether or not the interior roads in a 10+ acre subdivision are adequate for emergency services vehicles. And at that point, you know, the radius of a cul-de-sac, the width of the road, any prohibitions against parking, those things all come into play. So if there's a narrower roadway, less than say 60 feet, if a cul-de-sac has a very small radius where an emergency vehicle could not get into the subdivision and fight fires, whatever. So that's where we are. It's sort of it's a backhanded way to back counties out of large acreage subdivisions. I'm not sure why they picked that one out, but they did. And so that's where we are. And that, you know, we've gone through the regulation before that several times. And so I think the regulation as it stands now, making the changes that are indicated, would probably comply with the law and also meet your local needs. But I need to hear from you what you think.
So, Mr. Bass, this is Bob Reese. Can you hear me?
Yes, sir.
So in 1.3 paragraph D, where you mentioned the change from 5 to 10 acres, that's a legislative change?
No, the county some time back decided to go to 5 acres. And that's why we had interior roads per se were subject to regulation. The legislature uses 10+ acres. And so that's why we felt like we needed to back up from the existing 5 acres to correspond to the statutory, because the legislature, the way they worked it, if you divide a subdivision into lots of 5 acres, you should not be exempt. As I read the statute. Only 10+ acres. And I urge I think the 10+ acres includes more than 10 acres is what the statute calls for. So if you have roads would be outside of the 10-acre determination, you would not count the road in the lot. You would need to stay, each individual parcel of land would need to be over 10 acres. And that they all need to be over 10 acres. You can't have some 5-acre lots and some 10 acres and claim that exemption.
Okay, I don't know if I missed a meeting or something, but I do not remember us changing from the more than 5 acres, we have to plat subdivisions to more than 10 acres. In other words, 10 acres or less, or 5 acres or less. Am I missing something?
I don't think you are. The county itself opted to go to 5 years under the rules as they existed pre-93 legislative session. And so when the legislature changed the rule to exempt 10+ acres with no public dedicated streets, that forced the county to make this change here from 5 to 10 acres.
Yeah, okay, go ahead,
Justin.
Justin.
This is Justin Beckham.
Hi, Mr. Bass.
How are you?
I'm just fine. Bob, I think I can clarify a little bit what your original question was. The legislative change was by exempting private roads. So the previous statute had that language that's in paragraph D2. Or for the use of purchasers or owners on lots fronting or adjacent. That's what the legislature removed. With regards to the 5 and 10 acres question, Mr. Bass, the exceptions to the plat requirement are in 232.0015
Correct.
code, right?
Yeah.
And A of that specifically says that a county need not require platting for every division of land otherwise within the scope of this subject, correct?
Correct.
So that means that the statute has the basis, the floor of what is exempt, but the county can exempt over that, correct?
I think the county can add additional exemptions. But
okay, so you agree with it?
Yeah.
And so that was what was done previously with 5 acres, correct?
That was my understanding, yes, sir.
And nothing that changed in the statute changed relative to that at all, correct?
Other than the exempting private streets in large lots. I don't know that there was a demonstration of intent to exempt anything else. Now, I think,
but that previous large lot exemption applied for 10 acres, and the county previously decided to change that for Van Zandt County's purposes to 5 acres, correct?
that is the current rule, yes, sir.
Okay. So you're advising that the county not do 5 acres and that they do 10 acres, and that's also what you had previously advised the county, right?
The 10 acres is statutory. I don't know of anything that would compel the county to go to 5. It never really made sense to me, but the county wanted to go to 5 as long as there was no exemption of private streets. I did not see the harm of it. I do see harm if the lots are smaller than 10+ acres, and then you have virtually no, you would suddenly lose all your regulatory powers for lots of 5 acres.
I understand that's your advice to the county, and the county may very well choose to take it, but I just want clarity as to what's required by the statute and what's recommended by you.
Can I ask a question? Is the new rule prohibiting us to exempt anything over 5 acres?
Statute says that anything over 10 acres is exempt. You have the option, I suppose, to go to 5, but I see no reason to do that. You're just asking for largely unregulated tracts of land being subdivided. Anything less than 10 acres. So that is a big problem. I mean, you wouldn't have any subdivision authority for that under that definition.
I want to ask a question. All the things. So 5 acres, if another county, and specifically out of several counties, they have less than 10, that's still legal.
Yes.
Okay, all right, that's what I just want to make certain, because
Anything that's been approved to date is approved under the old rule. But going forward,
Rule says 5.
Current,
Current rule
current
says
is 5, yeah.
So
And it's not in conflict with the new legislative statute.
Right.
To move it to 10 would be the county commissioner making a decision to go from 5. You can make it or you don't have to make it. You can leave
Which
it
is
as
fine.
is.
Yeah. If y'all want to make that perfectly fine policy choice.
But I guess what you're saying is, know that the acreage is somewhat different because of the change of item 2 on how the roads are accounted for.
the question comes up, if a 10 plus acre lot is subdivided and they don't dedicate the streets to the public, they say these are going to be private streets. It says there's an exemption from the regulations of these requirements that are not applicable to that subdivision of land. So it does not appear to me that in essence, we could require anything. So you would have large tracts of land, large lots laid out there. And so if you make that exemption smaller, you are giving up your regulatory authority for any acreage of 5 acres or more. That seems pretty broad to me. It seems like it's excessive under the statute. You could do it, but whether you should do it is the question.
Go ahead, you.
Okay, I've been having issues on when we're cutting up 5 acre tracts and we're dedicating roads and cul-de-sacs. There's not much left out of that 5 acres cut, and if you're gonna hold with 1 acre tracts. So there's being a 10 acre, that 10 acre rule, you might have a little more flexibility on dividing it up to stay 1 acre and above all the tracts.
what you're talking about, if you're doing 1 acre tract, you're still planting it, though. We're talking about an exemption from the planning section. It's just whether or not you're gonna, if you keep everything above 5 acres, is it gonna be exempt? Where we don't have. Yeah, what you're talking about is actually just planning the rules, just not acquiring the streets.
Yeah, the way I understand it, Mr. Bass, you're kind of recommending is, you probably recommend to all counties that you work a new subdivision for that we plat everything 10 acres and below. And everything over 10 is exempt.
Generally, I think that's a fair statement.
Would that exemption apply if they cut a road through it? If they had to build a road to access the 10 plus acre lots, would it still be exempt?
Well, you're going to have to get to the lot somehow. I presume they're going to be non-compliant roads of some sort. Otherwise, you would just build a normal subdivision, dedicate those roads to the public. Now, just the dedication doesn't mean the county has to accept them, but you have to build those roads to a certain standard laid out in the regulation. And once you do, the county then could accept those, but there is a distinction. If you're not dedicating the roads to the public, you're exempt if you're over 10 acres. That's what the legislature says. If you lower the standard of 10 acres or more to 5, then I think you're opening yourself up to unregulated platting. I doubt if anybody would dedicate any streets to the public in a subdivision. They just say, well, we're going to have 5 acre, 5.01 acres. And as long as that 5.01 is contained within the lot, there's no land that's dedicated for street purposes counted in the lots. I think you're going to have a whole lot of subdivisions of 5+ acres and no regulation. And I don't think that's good for the public. I think it creates potential for unregulated growth. It's exclusively reserved for the rich folks, because a 5-acre lot's still going to cost quite a bit of money. Assuming a lot or raw land is selling for $8,000 an acre. I don't know what it is there in Van Zandt. I presume it's pretty high. But a 10-acre lot, 10+ acre lot is going to be up above 100,000 for sure. It's probably more like $500,000. Well, that means only the rich folks are going to be able to contemplate that kind of a subdivision. And if you want to build shoddy streets to a $2 million mansion, I guess you could. I think that's bad business. But the legislature's the other bill, the Senate bill, was by Bettenhouse, and he's no friend of counties. He's anti-county.
Yeah.
And has gone way out of his way to make counties suffer. And I think it's mostly for other political reasons, but I won't get into that. But we're just trying to come up with a consistent ordinance that doesn't have room for all of this quibbling and nitpicking. I think a 10-acre plus acre lot is a bright line in the sand. There's not much dispute about that. Now, where you have in the past used a 5-acre lot and now you want to bump that up, I think that is a political decision you would have to make. But the legislative language is for 10+ acres. It's not for 5. The county opted to go to 5 over my recommendation, but that was when even private streets fell under regulation. Now those private streets are being used as a gateway to no regulation.
On that note, can you give me a fair description of what makes a road dedicated to the public or not dedicated to the public?
Well, that's a good question too. A lot of subdivisions in light of that are coming in and making their roads open to all invitees, guests, commercial vendors, rural UPS deliveries. I don't see what the difference is that they're making a quote private street open to everybody in the world. It seems to me that the use of purchasers or owners of the lots fronting on or adjacent to the streets, if it's strictly limited to the owners of the lots, purchasers or owners of the lots, to their sole use, that's clearly private use. Public use is other than that. And so I'll be honest with you, I'm a firm opponent of this change. I think it's bad policy. But my job is to represent counties statewide, some rural counties, some urban counties, but they all have to grapple with this. And there are a few counties that are welcoming the lawsuit. I think lawsuits are coming, but they have attempted to retain some jurisdiction even over the private streets in these large lot subdivisions, to the extent that a fire marshal, for example, can inspect the roads and determine if they're adequate for firefighting or emergency vehicle use.
May I ask a question?
Yes, sir.
So the 10+ acre are unregulated. We had elected originally to do the 5+ as unregulated. So to the commissioners, have we had any incidents that anyone knows of subdivisions or breakup of properties of 5+ acres in which we've had a problem with law enforcement or firefighting situations to not be able to get to a property? Have there been any incidents in the last 2 years of actual problems?
So far, they haven't been any incidences that I know of, but here's the way that we regulate that, and I think Mr. Bass has approved this. If you build roads into a subdivision with 5 acres or more, it still brings it back to the subdivision rules and regulations. They have to follow the rules regarding roads. So
that's correct. There was no distinction between a public road or a private road. It just had to be a road that was necessary to get to the lot. And if there was such a condition, you had to build it to a certain standard. So the 5 acres was not a problem exempting those because you still had the interior roads brought you back under the regulation. But the legislature now has struck the private roads. And so that means that any of those interior roads, they don't have to be built to any standard right now. And that's bad policy. I just think you're either going to have the purpose of subdivision rules and regulations is to conduct orderly, uniform development within your county that meets a minimum standard of habitability. So your drainage, your easements for public utilities, all of that falls under that regulation. And if you exempt 5 acres, then it's still going to be a rich person's game. 5 acres is a sizable lot. But I just think it's bad uniform policy. You really then have all kinds of disputes arise. You ought to have one rule. If you have more than 10 acres, excuse me, you have more than 10 acres in your plan and your streets are private, I think there can be a question about what private means, but if it's going to be private streets and you don't want to build them to a particular standard, you're free to do so if you're over 10 acres. But if you're under 10 acres, you're going to have to fall in line. Now that's a lawyer representing counties talking. I'm not a developer's lawyer. I'm a county's lawyer.
Well, how does this affect HOAs?
The HOA is the appropriate vehicle by which lot purchasers in a subdivision go together and they agree that they will pay a biannually, monthly, annually, however they want to do it. In my subdivision, I've agreed to a biannual 2 payments a year. And that has stayed, I've been out there now 14 years and it's gone up once. But I pay about $185 twice a year to pay for common areas. There's a very nice park with recreational children's playground, walking paths. There's a lake, the common areas in the subdivision. That's where the parks, squares, other parts of the tract are divided and set aside to public or use of the lot owners. The HOA then maintains the streets. Now, the city has since annexed our subdivision and has taken over a big part of the interior roads. They maintain virtually all of them now, but there are some that are not covered, and the HOA maintains those.
So the roads are not private?
The roads are privately held. If it's a private road of 10 acres plus, the roads are private and nobody's going to maintain those except the lot owners. So the county itself, in that case, if they say we're not dedicating this to the public, then the county says, fine, you're exempt, but don't ask to be brought back into the county road maintenance system ever.
Well, that's kind of what we're doing already on some of our subdivisions, because all I have involved in God. So it just depends on the intention of what the developer wants to do. Mr. Bass, I have a question on some of these exemptions at the bottom. It's marked in red. It says such common areas are to be clearly marked. And it says that the owner does not lay out that part. So how do we define clearly marked? Is that a typo, or because I saw that numerous times in these exemptions?
Well, the common areas, the squares, parks, or other parts of the tract intended to be dedicated to the public need to be marked on the plat. They need to be.
But it's specific. These are the exemptions where it says that there are not going to be streets, alleys, and parks.
Mr. Vogt is identifying one of the things on my list, one of the instances of just poor drafting. This comment that such common areas are to be clearly marked has been copied and pasted onto all of these exemptions, and it's not relevant to the exemption. What the exemption is saying is that the exemption applies if there's not a common area. And then there's this copy and pasted sentence that says common areas are to be clearly marked. It just adds confusion and
well, if you've not dedicated your streets or any other parts to the public, then that notation, as you say, it's still applicable to the public dedications. It's not applicable.
But it's not applicable to the exemption where it's written. It's also written later in the text at a place where it makes sense. But it has no meaning in those.
You're dedicating a park in your subdivision to the public, you need to mark it on your plat.
Well, that's fine, Bob, but that's not what this exemption's about.
If it's exempted, and therefore it's not gonna be a subdivision, it doesn't need common areas marked.
There'll be no flat.
Yeah, there would be no plan, it's not gonna be submitted for approval anyway, it's just a cut and paste.
And then I have one other thing, under the state law, under exemptions, it talks about lots being sold to adjoining landowners. I didn't see that. We've listed all the others, and I know why the state legislators have that, because a lot of times we have issues with fences that were built in wrong areas. There's no stipulation on size or anything else. It's normally because two landowners are trying to do something amongst themselves, like I said, sort of a fence area that was built in area or whatever. I do that quite often, but if we're gonna list the exemptions, wouldn't they all be on?
I thought I had caught them all.
That's, it's 232.0015. Down on, let's see here, it's item I3 under the state law. And actually, the verbiage on there, I think somebody kind of went on a tangent because it talks about floodplains and then it talks about floodplain going to adjacent owners. But if I'm reading the law correctly, floodplain area does not have to go to an adjacent owner. That's a different line. Floodplain is floodplain. I mean, if it's in the floodplain, it doesn't count. But in this case, I think the state legislature's intention, at least my reading of it, was like I said, if there's an area where a fence was built, which I've done before as a surveyor, fence was built in the wrong area, they wanted to move the property line over to the area where the fence was actually built. I wrote a description for it and one owner transferred it to the other just to clarify, where that thing was built in error. But like I said, I don't read that in here, and if we're gonna address them, put them all out there.
You definitely need that.
So.
All right, I'll look at that. I think I'm not opposed to including all of the statutory exemptions. I just don't advise the county to have less than 10 plus acres.
When you're saying we need to make sure all the exemptions are out there, because a lot of times, for most people, they're gonna come out to the county website, pull down the subdivisions, and that's the only source they're gonna use. It would be very good to have everything that's possibly listed at the state level. Like I said, adjacent owners, that needs to be in there, because if not, they won't be aware of it, because they won't look anywhere else.
And I think it's very right here in theirs, it's like it says the division of land and public buildings. If I'm reading the way that's worded there, I don't know, I think the verbiage is a little bit weird, a little different. Because it says and, floodplain and.
Right, so
That's not what the rule, the law is.
well, I'm looking at the law, and that is how the law reads.
Has it got and?
Yeah.
I will look at the
And
statute.
I may have mistaken it, if that's the way to, if he's looking at it.
What are you asking that we just make the exemption?
I didn't see that in the and, I thought was inclusive, but Tom, he's saying that that's the way the state has it also. So, I guess everything's fine there.
But that is a very common issue that we see a lot. And one way to resolve boundary line disputes is just as Dennis suggested, having a deed from one owner to the adjoining owner for the disputed part. And if we were thinking about what works for Van Zandt County and what might make sense, so that y'all didn't have to deal with a bunch of variances for people who have fence line disputes. That may be something to explore.
A good example, we just resolved one the other day. There was a 45-acre tract. And almost maybe an eighth of an acre separate tract between that tract and a farm market road. It had an old cow dip, where you run, and that was the only thing there. It had been filled in, and it would be terrible to have to plat a tenth of an acre to convey that to settle that issue. So like I said, that right there, where it says all about joining landowners, that suffices and takes care of those types of things, because they have one time where a road is cut off. Right across the road. That's not the rear, that's mine. And then on the other side, it's the opposite. I have a little part, my neighbor, a little part there, we're fixing to swap out acreages and nothing more than maybe a tenth of an acre.
Usually when that comes to my attention, I don't look at it as a subdivision because you're just adding it to your large acre. We're not making a small lot. We're just moving that acres from this parcel to that one, and it's all staying a larger lot. We're actually cutting out something smaller. That's usually how I look at that when it's brought.
And I think that's how the state legislature, it's just trying to do what can.
Mr. Beckham, do you have anything more that you want to address?
I had a few things. There are, some definitions that have been added, that don't seem to have any bearing on anything, other than the words have been added a couple of times, but a driveway approach, a dwelling unit. There's now a definition of a flag lot, doesn't really seem to change anything. We had, a rental short term is a defined term that doesn't appear anywhere in the document. And there's just some language stuff that I think makes sense based on our earlier committee meetings. But of adding, tiny homes and campground, language to, chapter 5 regarding recreational vehicle parks. So I just would point that out to y'all and make sure that y'all look at that. There's a comment that Mr. Bass made, paragraph 10.4.
10.4,
Yes, so that's
what page?
45 is what I showed. That may not be correct.
Ten point four talks about vacating a plat, where the developer may vacate a plat at any time before any lot in the subdivision is sold to a purchaser. I don't find that in the county provisions, and there's no clear reference to the municipal code. So that's my comment.
Yes, 10. Do you have your local government code?
I have one somewhere here. Hang on just a second.
That's the one we've resolved already, haven't we?
I'm just addressing this comment from Mr. Bass, who thinks that we can't do this.
Well, I thought we changed that. We talked about that.
Go ahead. What was your reference to the local government code?
232.0095. And it says that a county may adopt the procedure in the municipality code, which is actually 212.013, not 913.
Have a typo there, 013.
Yeah, I just wanted to clarify that's perfectly fine what we have there
Yeah,
previously.
I think we had worked on that.
I may have left that notation in from when we made that change, but I can delete that notation, but
You believe that that's gonna be pretty, I know of 2 divisions that are gonna be vacated probably. I mean, they're waiting to see make sure the time they get it done, we're compliant, we're going to vacate. Actually, one's gonna be in your precinct, the other one's gonna be in Will's Point, that are pretty big subdivisions that never developed. Sat there, now they want to go back to farm and ranch.
We did one, didn't we? Yours, yeah, we did.
And on those deals, you don't have to come back to the commissioner's court for that. To vacate a plat, you just file the proper paperwork with the county clerk and that's it. Is that,
That's
my understanding?
Yes. So that may just be an old note that was in there, but, and then on the appendices, there's still no appendix B or appendix D. And appendix R says it's a letter of credit, but it's not a letter of credit. Appendix R is a document that seems to be linked from LexisNexis. That's a subdivision construction agreement. And it refers to a letter of credit in paragraph 11, and then subsequent to that. But it's just, it's not what it says it is. And so, that's not helpful.
All right.
Oh, I have a comment on the very, very beginning, the first very top page, Mr. Bassett put down on there about the notarization, notary for the judge's signature, and about, he didn't, say that final requirement. I've never heard of that from an elected official either, and then the last plat I submitted, they made me put that on there. Are we removing that box, or are we gonna keep it?
The notary?
Notary for you.
Well,
It's not
if
required.
it's not required, there's no need for it.
I turned in the plat last time, and they came back and said that was the one of the deals that we needed a notary, and I'm like, you're gonna notarize an elected official? I never heard of such a thing, but I went ahead and put it on there anyway.
No.
I
So-
can tell you the reason why they were asking for that is because the tax, and I'm not saying it was correct. Just for Patrick, we always have their signature notarized, they were talking in, they don't know who made that rule. They were just following from the original. Just.
Well, I never, like I said, that's,
No, that might have-
you know, and I
Now, you can put it on there, Dennis,
Well,
and he'll sign it, notarize it, but you don't have to.
Yeah, I just had never heard of an elected official having to get a notary. It's like, he is what he says he is, so.
Yeah, but the notary's verified, he actually signed it, somebody didn't forward it and turn it in.
And I can feedback what we did in Montana the other day, you know, they had to have his certified signature to say he wasn't, they wouldn't accept it in Montana. They just don't know like the judge in Montana, you can get out.
I'll try to doing that.
Here it's kind of cold.
Yeah.
So with that being said, just because, you know, when you file something in the clerk's office, like, you know, you have to have the original, usually you have to have it notarized. He was asking if their signatures have to be notarized. Okay, so some of these things.
I'll file something not notarized, and I'll file something with notarized.
Well, the state, I disagree, the state said I am, but I don't know. That's the reason I have to seal it. Yeah.
Signature and seal, or take care of that.
That's what I'm saying, it's the state, if somebody's putting my signature and still on something, it's fraud. That's kind of like how I feel about our judges, if somebody else is signing that, you're certainly, I mean, they could just as easily, you know, commit, if they're gonna commit fraud, why wouldn't they just fake the notary too? I mean, you have somebody as an elected official, you elected, that's the official. And he is who he says he is. If somebody's trying to circumvent something, I don't know how adding this little notary thing is gonna change that.
And also on the surveyor seal, we got legislature and a bunch of our courses, we had to go continuing education. And they tell us by law, we have to protect our seal, because that seal is the one that says we're who we are. And if we don't protect the seal, then we're in.
That's right.
Okay, all right. Can we move
I've got-
along?
I've got
Go ahead. Mr. Bass, go ahead.
Mr. Mayor.
Mr. Reese, did you have something to say?
4.D.5 on page 13 of the red line.
4.3?
We've 1.4.D like Delta 0.5 on page 13 of the red line. Talks about the culverts on the county road right away. It states a minimum length dimension of 24 feet was wondering if there needs to be a width also. Length would appear to be, from the road back onto the property, but there's no width given.
The width,
I understand it, depending on the topography, the
Yeah.
width, but there is no standard for the size of the culvert. It might need a 12-inch might be fine in some places. It does need to be a certain width to accommodate the road that accesses the property, for example, with a culvert underneath. But it might vary between 12 inches and 36 inches. I don't know what the maximum culvert size.
well, that would be determined, that would be determined by the commissioner on inspection. He would tell the developer what type of culvert he needs.
So we have the culvert permit for it.
And also the engineer ought to be.
Okay.
And there we go. Send it through him.
Okay, so that sounds okay. I just want to bring that up. Secondly, the names of the commissioner, some of the commissioners and the county judge needs updating on the signature page. And the final thing is, I want to go back just briefly and say, I suggest we leave the platting requirements to 5 acres or less at this time. Most of the larger tracts that I've seen that are more than 5 acres anyway are already on a county road or a farm to market road. I think we look at changing this possibly in the future, but for now, allow for economic development and the attractiveness of the freedom of private property rights that exists in Van Zandt County that makes it why people want to move here. That's just my comment to the commissioners.
I think that makes a survey about this 5 acres. Here's kind of the way that I've always had the impression the commissioner went. If we have an existing county road, we have electrical, we got water, access to water. Then we could cut out the 5 acre tracts because no roads or construction being built into it. But once we had to cut a road in to do it, then we would always tell the client, look, you're building a road, this is now a true subdivision.
That's right.
There's so many times everybody confuses subdividing land with a subdivision. If you cut a road in, that's a subdivision. I don't care what you say. Then, if you take and cut them just off of an existing county road, 5 acre tracts, they've already got the electrical, they already got the water, they already got everything out there typically, and you're not building anything inside. So that's the way the commission has kind of always went with a 5 acre tract. But if we ever cut a road in there, then that stops that because that becomes a subdivision automatically then. And it for sure comes under any ordinance in the subdivision.
What Mr. Bass is saying, now, change the legislature, that road that's one is a private easement.
I know.
That's what he's saying.
But here becomes the complication on this. There was a subdivision did up in Wills Point, and they cut out 10 acre tracts all up and down this road. Well, they made this road a private road, but the surveyor that did it failed to give a right of way easement to the last tract in there. So then they had to come back in to get that right of way down there because no bank's gonna loan any money over this on a private road. You gotta have an easement up and down that private road. It's gotta be attached to every track on this road. So the way we always did it whenever I was doing something, we had a clause over there that said all these roads are dedicated to the public. And they're for public use. So then that's not what you're having to write on the right of way easements up and down there. But then whenever the county used to, after a couple of years, they would adopt that road as a county road and we never had to worry about it. And now then we're getting into these HMOs and we're getting into the county not really wanting to take on any more responsibility of roads. So then that means they're gonna have to be easements, road, that would track in this subdivision. If you stop it from being a county road, so it already said, and then answered the Brad's question, how do you determine it? On the plat, we already put the dedication of the road to the public. So we never had to worry about ingress and ingress to be boxed.
And that kind of brings me to a point I was gonna ask. I'm glad you brought us to this point. In the definition somewhere, can we get a clear-cut definition of public roads? When I asked that question, you gave us a nice long answer that never really summed it up, in my opinion. And this is very important to me on this issue because if somebody's got 110 acres out there, they could cut it up into 5.01 acre lots and put a dirt path and circle it all and say, we're good to go, and we have no control. And you know, I got 30 years firefighting. I can tell you right now, getting a big fire truck down a dirt road, it ain't easy. And with 5 acre lots, they could be narrow enough lots. You got stuff close to each other. It's not like it's a house out there by itself anymore.
Used to be, as soon as you built this road to get to a lot back there, it becomes a subdivision, come under the one.
Yes.
Because you built the road.
Mr. Brady, you nailed it on the head. The problem is the 5 or the 10 doesn't matter. Because of the next clause says, if I don't make it a dedicated road, I can develop it, and not make it a dedicated road. I can take 50 acres. And I can make it look like a checkerboard. With dirt roads, I can put trailer houses on every lot, and I can do 1 acre lots. And there's nothing anybody can do, because I don't have to subdivide.
And that's kind of where my question is coming down to.
That's why I said there's a 5 or 10. I think Bob Reese has a good point. 5 is a less deterrent, which encourages development, if that's your goal. If your deterrent is to create people that have to really think how they're going to do this, then maybe 10 acres is more appropriate. There's a purpose in that decision. It just depends on what you're looking at, development or deterrent. Because that next clause is going to make anybody that really is looking for a loophole be able to do whatever they want to do.
That's what worries me. They do what they want to do. They can actually create a hazard setup, or they can create a situation where no one's maintaining a road.
Well,
I got a private road north of Fruitvale that you can't get down. County can't touch the private road.
The problem that it puts on the county and the commissioner is a developer will come in there and cut it up, put dirt roads, sell it. And then y'all have homeowners 5 years later coming and saying, hell, we can't get service.
But is there not some other way to regulate private roads? Is it just not possible to have some sort of, you know, I mean, the septic standards or something else? Is there not a way to try to keep these, you know, hot roads from being put in?
Was that not in the rules right now where those roads have to meet a certain standard?
They are, but the law allows that you don't get the exemption if you put a road in, so you automatically fall in and build it. Under this new rule, and what he's saying, if they declare it's not a public road, they build whatever they want. And that's why I want a clear-cut definition. What's a public use road and what's not?
That's where people will find a loophole with no definition.
And that's what I'm trying to keep.
And the thing is, if it's a public road and it's dedicated, it's a public road, are you not required to maintain?
No, there's a difference in a public road and a public maintained road.
Really?
Yeah, a public road is a road that's open and available for the public to travel down, regardless who maintains it. A public maintained road is one the county is maintaining or the city is maintaining. You can have a private road, and if it's open to everybody that lives in that subdivision to come and go, and their family and friends come and go, and a UPS truck comes and goes, it's a public use road.
Really, any dedicated road that is not accepted by the county is not maintained by the county, and it's a public-private road, and it's privately maintained, publicly used.
But where is the actual definition of that, like you said, to secure out the loophole law?
Yeah, that's the hard question.
That is.
Is trying to come up with a
I mean, that's the way to look at it. You have public used, public maintained. You have privately owned, privately maintained. You have public that's privately maintained. There's these categories that they just keep on saying public or private. It's
We
not
take-
that clear cut.
Can we get a definition that clear cuts it so we can tell people, you're putting a road in there, but you plan to let the public use it, it falls under the subdivision policy, or you're doing it in no public, what is that rule? Where's it at?
That's a good question. There is no such definition.
Wouldn't we be able to regulate the roads, if we, went to platting, 10 acres, if a subdivision's less than 10 acres?
So that's the bad part is the 10 acre really doesn't make a difference. It's what you say the road is. Because if you declare it a private road, then I don't have to plat.
Well,
Yeah,
I think that may be a little overstated in just thinking about it, because if you lay out lots, whether or not you lay out a road, then it's a subdivision.
That's
that falls
right.
under the ordinance.
that's right.
And so the exception, the private road part of the exception really only applies if the first part also applies. So the 5 acre, 10 acre.
I look more as if you have a 50 acre square and you got county roads on 3 sides and farm market road on the other. And I sell a lot and they do a private road, a lot, a private road, a lot, a private road, or I put a road all the way, just one road to it. But I don't sell off the rest of it. It's one of those I develop it as I go. Or I sell off as I go and do private, what I call a private road.
But every lot faced a public road.
Good.
So if it faces a public road,
And
you have to worry about it.
No, I'm more concerned about that 100 acres, they want to cut into 5.01 acre lots and say it's private roads. Now, there's no regulation over that 100 acres being developed whatsoever, and they can put whatever kind of road in there they want. No one has anything to say about it.
Well, and that would be an argument in favor of doing what Mr. Bass suggested, which is have it be 10 acres, just to track the statutory exemption.
You still got the same problem, you just got houses further apart, because it's 10 acres versus 5.
That's
It's a deterrent, like I said, it's more of a deterrent against what we want to happen. Versus it actually, if it's 5, the purpose of 5 over 10 is probably more developing, encouraging people to.
But the pros and cons of the 5 and 10, you also have to take in the economic and, real estate and everything else as far as what will be able to be sold or how you want to affect development and scale.
It's commercial
And
versus
certainly,
residential.
which is kind of where Mr. Bass, and Mr. Reese is coming from. And contrary to what Mr. Bass had said, from what I'm saying, 5 and 10 acres, there's not much different. You don't drop down greatly and great right. So, it's not just serving the rich, it's considered, either way, it's expensive. It's just, that's an extra 5 acres. It's so much financing for the home.
Bobby, Mr. Bass, is that correct? If it's 10 acres or if somebody divides something that's 10 acres or less, we have no say so in the roads if it's private? Is that correct?
10 acres or more, you have no say. If it's less
But-
than 10 acres or 10 acres, not more than 10 acres, you don't have, and they choose not to build a dedicated road to the public, then you don't have control over it. If it's 9.8 acres and it's not dedicated to the public, you still have to plat it. You still have to meet the subdivision regulations because it doesn't fall under the exemption.
That's right. So we do have say so in the roads.
Yes, they have, if they're gonna,
Under
now
our current
if it's
system,
not, if it's a 10 acre, or say it's a 9 acre lot, and they lay out streets that are not dedicated to the public, it still has to meet the subdivision regulations because they're selling lots.
Yeah.
Now, the street is not part of the lot. The street is set aside to the public, or it's reserved to the developer, or it's sold as a separate tract, it's not gonna be maintained by the county. Then it needs to be handled in some manner. Now, how much maintenance it gets? Do you allow street parking? Like you say, you could have a county road, but if it's too narrow and you allow parking on the street, then you try to get an emergency vehicle in there and you can't get through, because cars are parked on the curb and not in the driveway. There's all sorts of problems with not having a specification as to road width. But if it's exempt, you don't have any regulatory authority at all.
And right now, our exemption is 5 acres, so if they done 5.01 acre lots, we'd have no control of the road.
Well, currently you can't fall under the exemption if you do any road. So this is under the new law. So
Yeah, but that's what he's saying. If we stay with the 5 acre lot and we go under the new law, 5.01 and above, we'd have no control. It wouldn't even have to be platted.
correct.
Okay, when you're laying out these subdivisions, and we go to the right of way and there's a dedication, and the county doesn't take those in for public, they remain private. The developer still has title to that strip, don't they?
No, if it's done right.
Not if it's done right.
Yeah.
Well, I'll tell y'all, the county has no business taking in any new road. We cannot take care of the roads we've got right now. We have no business taking in new roads.
So should we take our title out past the road and do a county road even? I mean, like an easement for the width, 60 foot, and each lot would go into the road?
I didn't say the county didn't have any say so in how wide they are. Yeah, they should be a certain width and they should be built a certain way, but we should never take in a new road. Can't take care of the roads I got now.
I have just one more housekeeping thing, Judge.
Okay.
This is on the section on setbacks from the road. It's paragraph 3.10. Page 24 is what I've got. So the standard setback is 25 feet from the edge of the right of way of any public road, and then 50 feet from major highways and roads.
What's section?
310.
Well, use it, just general.
Yeah,
Right there?
a little further. Yeah.
27.
So right now, the difference of 25 feet and 50 feet, 50 feet applies to any state or federal highway. And then there's two blanks there. If the county is not going to designate any other roadways as major roadways that require a 50-foot setback, then I'd recommend deleting those just to avoid any confusion. But if
You're
there are any
correct.
roads,
You're correct on the interpretation. That gives the county the option of putting any existing roads that are more highly developed but are county maintained. So I think the county can always designate a county road as a major roadway. If you wanted to make all of your county maintained roads, you could make that. But, a lot of these subdivision roads are going to become a bone of contention, but they're 25 feet unless they're designated as a major roadway. So the county needs to I left those blanks simply to show that they have the option. Now, if you take it out, it suggests that they cannot designate, but I think they always have that authority to designate a county road, for example, as a major roadway.
yeah, it specifically says in paragraph C that the Commissioner's Court has that right. I just think that if the Commissioners Court is going to adopt any roads, then they should be listed here. And if not, we shouldn't have fill in the blank in our laws.
Well, however we want to do it, I just need some direction, I think.
Right.
I heard that. How about if we made Lawrence Springs Road? Any volume, that road or Percival Road, both of those.
Definitely good.
I have a question on, there's a grant in there, so that talks about, travel maintenance, the volume of travel.
It's like appendix
Yeah, I don't remember.
M
what it
or
is.
something.
I was gonna ask about that, some questions about that is, do we have a study, is there a list of all the roads that have the traffic and all that? It looks like that was taking a more urban area than what we have, 'cause I didn't know that we had a traffic study.
We had a traffic study in 2018.
So there's a list of all the kind of roads.
This is all the county roads and what condition they're in and what needs to be done to them and
Well,
what.
this is the volume of traffic that goes back.
I'm sorry, 2015.
It's on the website, our website.
So that would be rated the roads.
Yeah.
Yeah, it's all been.
Priority need.
Well, I remember when they did it as far as what it was and how it was, but I didn't realize it had the traffic, the volume of cars, isn't it on that?
I don't know that it had the volume of traffic.
Well, that's what this appendix is. Oh, I think it's, did you just go past it?
Appendix M.
State supersedes.
There it is right there. See, it says the average daily traffic. So that it would tell us what a major road is and what a, classification is based on the average daily traffic. That's what I said. I didn't think we had a true traffic study. I've seen that in a lot of other counties, but they actually have a traffic engineer that's been paid to, you just gonna lay up the strips and determine how many cars walk down that road, every single road.
It's easy, let's make them all 50.
Yeah.
County roads and major roads, like a 50-foot setback.
Yeah, well, and I'm not just talking about setbacks, if you go back to the minutes, it talks, there's other things in there that talks about, what the links of this, whoa, right there, where it talks about radiuses. I mean, it's all broken up, but it's all based on average daily traffic. And then it tells you what a local street is, a minor collector, a major collector, it tells you which one. It also designates speeds, and I think y'all addressed speed limits on our county roads last year. So that right there wouldn't apply, but when it talks about the other stuff, and it talks about right of way, which we've always gone 60 on all our roads, but if there's somebody, something, if we have a road that has over 2,500 cars on it a day, apparently the right of way is supposed to be something different. But it looks like this was cut from some urban thing and put on here. And I don't know if you can give me a list of all the county roads and how many.
I don't think this was designed for county roads.
How many county roads have a 25-foot setback from the edge of the road? Maybe the center of the
From the
road.
center of the road, not from the edge.
There's some, I mean, I used to mow the county roads. There wasn't enough to mow.
Well, I think when we talk building setback, I think this.
There's no setback on the county road unless you do a subdivision. Then there's a setback. If you've got property on the county road and you built something on it, you can build it right at the fence. We have no say so on that. It only if it becomes a subdivision.
But does this appendix M need to be in here if it doesn't?
If it's not,
It doesn't fit us?
there's not gonna be real data.
Typically, we always went from the center line of the road, we come over 30 foot, and fence was over here, another 10 foot closer to the road. We would show that 30 foot from the center line as the actual right of way for the road being in the subdivision. What we used to do.
That's correct. Yeah,
And this in here saying something about sometimes it's 70 feet and sometimes it's something else, but I don't think any of these old county roads, most of them.
We might need to delete
Johnny,
it.
what's that?
Well, that's what I'm just saying, I think this is finished, cut and paste on something.
Yeah, I
Doesn't-
think-
That's more of an urban
Right.
area, more
Yeah.
than rural.
It's definitely an urban thing. I thought.
Yeah,
And I know about this stuff that he's talking about, where we said that each road was such a distance and it was made out of, oil sand or what have you, so, but I didn't realize we had done the traffic study so that I could even use this.
The,
Oh, a traffic study was done in 2015.
Yeah.
It ain't accurate today. We've grown a lot since then.
But they did include daily traffic.
no, it did not.
I don't,
Those
I
road
think,
conditions.
the road study wasn't true traffic. So,
I've got a question, Mr. Bass, on a clarification deal on section 55 point B3, 5.5 B3. On that, on this, does it mean the men's and women restroom must have exterior access points, or can it be in a large building with interior access points?
It's an RV park.
Mm-hmm. 33.
So they're talking about service buildings. You need to have a lavatory for women, a lavatory for men. And that third point could be possibly stated, or maybe put, but you need one lavatory for the women and one shower for women, one lavatory for men, one shower for men, so.
Yeah, but do they have to, shouldn't it have exterior access to those, or does, it's just one big, everybody comes in and then goes?
With an exterior to eat a segregated, lavatory for women, for example, has to have its own exterior access.
Right.
We can do that.
I think that would be best.
Understand, they can still be in the same building, they just have to have separate entrances.
Yes.
Okay.
and sealed off from each other.
Yeah.
But you're not requiring the bathrooms and showers all to have their own separate
No,
exterior access. It's just like I said, you go into one big building, then there's an entrance and entrance and entrance.
That's right.
No, it's not.
Or you can have
Exterior.
exterior entrance.
Separate ones on the
Yeah.
outside.
Right.
You have a men's side and women's side. It's a matter of whether both of them are from the outside or you come in one main building and then go on the women's side or the
Right.
from the men's.
I'll give some attention to that.
And on, also, what tier, I've had some problems, what tier is an RV park and manufactured home park fall under? What tier does that fall under? What would it fall under?
I think normally it would fall under your regular subdivision rules, but it could fall under a tier 2, depending on how it's laid out. I don't know how to address that. If it's a big park,
Yeah.
you probably apply your regular rules. If it's a small park on small lot, probably the second tier would work.
Would we not address that as to how many campsites for that?
Well, yeah, I mean, so if we got a RV park with four lots or plots, it would be a tier 2 deal.
Unless you cut a road in.
I wish we could just make it a certain tier. Tier 3.
Well, when
You
we set
can.
up the tier system, we weren't even doing all the parks, that came after the fact,
Right.
and it kind of muddled the waters.
You could just say that, RV park is a tier 1 subdivision.
I think that'd be good.
So that means it's gonna bring the road conditions up, but there was 2 different road standards for tier 1 and tier 2. Wasn't there?
No, sir, I don't think so.
Tier 2 had no roads at all. They accessed a public road. If it's got any kind of road, it makes it a tier 1.
Right. And there's specific rules for campsite roads.
Yeah, that's what I was wondering.
No,
But that road, they're gonna bring them up to tier 1 standards or keep them like they are.
It's a good question.
They have to be able to have emergency vehicles go through there.
Sir?
They have to be able to have emergency vehicles, like a public road, emergency vehicles and everything to go in there.
So that's why I wish we had some kind of building standard, we could put that down, you know, if you're gonna build something. Then you have to address the emergency vehicles, you're gonna be able to get there to help those people if they need.
Section 5.5 also, could we explain the difference between a flush toilet and a lavatory?
Yeah.
AISS, keep it simple, sleeping.
If that could only work.
Yeah, that's coming. You have to have 3 bathrooms. A male, a female, and
Unless they identify something other than those 3 categories,
well,
then you have to have a miscellaneous.
However they identify.
I don't know which one was. Yeah.
Yeah, that can about it.
Used to use probably the next city, like,
Are we going to still move on to building codes after this?
no, this table that.
Okay.
Without me, it's all.
I had some people. I need to do some more stuff over there.
I'm just also wondering, should we add some language into, about stormwater pollution prevention plans and erosion control plan to meet the requirements of TCEQ permit, general permit? That permit is at 150000. I'm just asking.
Aren't the requirements in the permit?
But we don't have any requirements of that permit. I mean, I don't.
Didn't this be your authorizing document, I mean, for that the permit process would follow?
And that's, yeah,
I said, one-stop shop, you're gonna look at this and go and dictate what your expectations are for the permit process.
Oh, one thing I touched on earlier about the fees for the RV parks and stuff, there was the appendix that showed the fees. Is that fees listed someplace else in the document? I just missed it, or is it gonna be added to the fee appendix? I just had a fine answer, but that's what
I would assume the fees should be in one spot so they can
That's what I would think that would be easiest if the client's going to go to the website and look at it, that all the things will be on the same appendix. Where they just sit there, okay, we know what we're looking at now.
Storm waters are not mentioned per se. Storm drainage is mentioned in the introduction, but not elsewhere.
Right.
I think it would be a good idea just to include compliance with TCEQ rules. I'm sure we do that, but it probably wouldn't hurt to do a direct reference to the statute.
I think we probably need to include that.
Appendix Q, is that what you're talking about where the fees are?
Yes.
So that should be the only spot where they're in there so that we don't miss it if we change.
Well, I just think right there would be a spot where it says, you got your tier 1, and of course, if you're gonna designate all these camping sites and everything, it's a tier 1 subdivision, which I guess that's what y'all discussed. But the fees aren't exactly the same there, is what I was told. So what are the fees on an RV on a camping site? And is that gonna be, that needs to be there so that everybody knows what we're dealing with?
Got one. So much per site, don't we? Up to 100 sites or whatever. I've seen it.
That's what I said. I made a mistake because I just didn't scan across this thing the other day and it made me read in there someplace else. But I thought it would be a good idea to have it right there. So that any clients looking at it, they're just gonna go to the fee page and then they know exactly what they're looking
Yeah, there's more to it than that. It's so many per site. If you go over 100, it's X amount of dollars more per site. If you go over 100, I can't remember what it was.
I'm with him. We need to put it on this appendix where people can go see where it's at.
What's
when they
the-
go down.
And I have a question, what if they go above 100 sites? Doesn't that totally change the rules of what we're doing this? I had one Pacific guy tell me that once you go above 100, you totally change the game.
I know the fees are different.
Don't they have to have like their own sewer system? Once you get above 100 sites, 100 sites or above.
Even out there at the Ponderosa, when they redid that, and that foreclosed on, they redid it, they put a new system out there, and I know they had put their own.
Yeah, I don't think you get to do septic tanks. I understand. That's one of those guys, that's not mine.
Yeah.
I was told, it's either 100 or above or above 100.
They had like 35 more units out there for what was listed, that they had this elaborate, expensive, I want to say $80,000 aerobic.
Yeah.
But it's something they had to have a dedicated so many acres just for the aerobic system.
It becomes more full blown sewer system. Just a second. Once you get above a certain number.
I just have a quick question, because I was curious, I know this has happened up in some places in California. What's our county policy when someone's coming in? Is there a trigger something that would trigger an economic impact thing? Like they do, like Forney did one when they were fixing to develop a certain area. The county or the city has to look at maybe engineering to increase water pressure and other things, and they would charge like $175,000 economic impact fee.
I think that's more an urban area where the municipality provides utilities.
I was just curious if there was any variation of that on large subdivisions, because large subdivisions make a huge increase in general services besides road and bridge.
It'd be a question for Mr. Bass.
Yeah.
Right now, there's proposed legislation that hasn't passed, but would give counties a corollary or equal authority to cities in designating economic impacts and the like. but it's not clear that we can do that right now. Some counties are doing that as part of their economic development package, but not generally. But I think if that needs to be done, it's just I don't know that there's clear authority for it right now.
And the little ones I'm aware in the counties that charge the economic impact or community water. You know, if you're gonna put an RV park, you need to pop in with what it takes to get better pressure to 36 faucets or something like that. And they're charging, and they say it's $30,000 upcharge. As you figure, that would be a bad thing for if all of a sudden this county road fixes get pounded by, 40 house subdivision, that county road. Traffic quadruples. There would be an ability to do that later.
Mr. Bass, should, definition of a manufactured home, include an RV,
No,
sir?
RV is something different than a manufactured home. The manufactured home rental community, for example, uses federal rules to define what a manufactured home is, meet certain standards where RVs they're not up to that standard.
Okay,
Manufactured home has certificates.
yeah.
It's specified what they are.
If an RV has a shower on board, built-in shower, it has its own tanks to hold fresh water and gray water. There needs to be provisions for dumping that and so forth. I think those are covered, but trying to make a subdivision rule apply to a 30 space RV park. That's why you have the individual buildings to accommodate the users, the small camper that doesn't have its onboard septic system or onboard disposal system.
I think I just have one more question about, the checkoff list subdivision. Should we, the very first one, meet with the precinct commissioner at least 15 days? And then prior to at least 15 days, and then add 2 review pre-submittal plans with commissioner and review engineer.
Where are you, Virgil?
I'm in the subdivision application checkoff list.
Appendix A.
Okay.
Yeah, sorry. I'm just wondering if that would help, look over a submittal plan with the commissioner and with our engineer to begin with. I don't know. That's up to the commissioner's court, but this we modified this.
I think that's a prudent thing. That requires you to have a county engineer designated already. Do you have one?
Yes.
Yes.
Okay. That's not a problem.
And that's something that the commissioners are gonna have to decide on too, whether they want that or not. I'm not sure how the court would rule on that.
Well, it needs to be somebody.
Yeah.
If you have it, meet with the precinct commissioner and he has a technical question and
That'd be a good idea.
it's not there.
We already had that set up in here.
Well, it's not specific.
I want to, one other thing I use about my attention, because it says when there's 6 reduced size, one of them talks about a specific size piece of paper, and then right there it just says, 6 reduced size doesn't, it should say which specific size piece of paper, because isn't it, is it legal to letter that you want? Can't remember, the last one I turned in, they had to reprint it because it was on the wrong thing. I always done it one way and then that changed it. Is it letter size that you want those reduced ones, or is it legal size?
6 reduced size, not to scale, copies of the plat, says legal size.
Legal size, okay. And so right there in this particular deal, it says 6 reduced size, not to scale, should say legal size.
Legal size, yeah.
Yeah, and there's some other verbiage someplace else that says that legal. And before I'd always done letter, and then the last one they said, no, I need to be printed, which is no big deal. Just need to know which one you need to get, and if anybody else needs to know, they want it legal.
We need to review this and we need to approve it. The commissioners court needs to approve this when we approve the subdivision rule and regulations. It should be part of subdivision rules and regulations.
And then the digital map, I'm assuming, reading the verbiage in there later on, it talks about the digital map, I guess is because the appraisal district is what they're at.
Right.
And I'm actually working on a project with them right now, and I haven't sent them just a generic PDF.
Yeah.
But I think there's some verbiage in there that talks about it being, geo-referenced and all this other stuff. Well, it's not, they don't have the ability.
Yeah, if it's available, I think it's,
If it's not, it just doesn't-
No. right. But it may come available.
But they're using a third-party vendor right now, they can't even use CAD.
Anybody have any more questions?
Well, one question, is the goal to adopt this before summer? Just depends.
I would hope that we could get this done. We've been working on this thing for a year now.
I didn't know if it was a
So I would like for Mr. Bass to take the questions that we've asked and the things we've asked him to add that and send us the revised subdivision. And we go over that, and should be what we do here today. We should approve that. We should set a hearing. We've got to put it in the paper 30 days prior to the hearing, and then we can adopt this stuff.
Are y'all getting any opposition or pushing for the 5 or 10? That's what I hear everybody talking, 5 or 10, and most of them don't even know what that.
Right. I've not gotten any.
See, if you read your ordinance, it tells you 5 acres, but then it says down below number 2, and if you're gonna do streets, it becomes a subdivision. That's in your ordinance. You know, you can't do 5 acres and build your road out there and have a road to it according to your ordinance, it becomes a subdivision. So it becomes under this, it becomes under y'all's authority and control. I think you already got it rolled into your ordinance.
It's just to make a decision 5 or 10.
Yeah, 5 or 10. But it's already in your ordinance, you're gonna control that road, any road built, you're gonna control them underneath this ordinance.
Right.
And I got one more question. Say I got 10-acre tract, I cut a 1-acre tract out. According to this ordinance, it says, if I cut this 1-acre tract out, it becomes underneath your subdivision ordinance. The way. So anything that I cut out from now on with less than 10, I got to do a subdivision. Is that correct?
Or exception.
Well, there's no exception.
Or a way.
It says, here's the way your ordinance reads, it says, if I cut out 1 tract, I might keep 1 tract. This is the one I'm keeping, I ain't going to sell the 1 acre. But the 1 acre has to go to a developer who intends on subdividing that 1 acre tract. If I'm gonna sell it to build a home on it, your ordinance says I got to subdivision. If you read it, I don't read it there yet, I found it, I lost it. But this is very confusing the way you got this written.
That is how the ordinance is written. If it's a 1-acre tract and you think you have a case to make as to why it shouldn't be a subdivision, we can come to the court and ask it for a.
The key is dividing land.
Now, anytime-
Any subdivision of land is potentially subject to the regulation. But if you have an exception that you think it meets, there is an exception that, for a owner retained portion of the original tract and a sale to one other individual, I think there is an exemption.
Well, then, but the way it's classified,
Not,
whenever I sell it, I got, that dude's got to subdivide. So that's in your ordinance, the way it's worded.
For that exception, that's correct.
But I didn't know no other exceptions that tells me if this old lady's needs 2 acres to pay her taxes. Then I got 2 options, the way I understand it. The first option is I tell the lady, okay, you wanna cut this 2 acre tract. Well, first, we're gonna have to come in front of the commission court, and we're gonna have to get permission for you to cut this 2 acres to have a variance. Before I can even cut out anything, from now on, everything is gonna cease to be cut out till I come in front of this court. I either got to get a variance here or do a survey. Well, that's all
Well, you-
2 options they do.
Yeah, you can do a survey for the lady of the 2 acres, because they're gonna wanna know what the 2 acres is that you're asking for variance on. If it's,
What I'm saying is, if I cut her 2 acres out, without coming in front of here, I gotta go to this engineer. This engineer told me he's gonna charge me $150 an hour just to look at it. Then what he's gonna do is he's gonna send it to another engineer to do the study. So now then I gotta do a topo or get the digital stuff to do a topo. I gotta bill it the topo. Then I gotta bill her to have it over here, and he told me it's about $500 to $750. So I got to tell her every time I cut a tract of land out, look, we either gotta go out to this court here and get a variance, or you're gonna have to come up and pay me to do a topo, do a survey of this. Then we got to send it to the engineer, and he's gonna charge you another $500 to $700 over here for him to send it off to somebody to get the drainage stuff done. And then he's gonna send it back over here, and then I'm gonna charge you to go back to him for another 2 hours to figure out what all I gotta do. And then I'm gonna have to go back on the ground and do some more work just to cut out a 1 acre tract for the poor lady.
You need to go around.
Well,
You know, this is the way your ordinance is written.
well, hopefully, this will be taken care of in the pre-submittal plan. Where you can interview with the commissioner and the engineer and get all that straightened up, see what you gotta do before we send you a bill. Huh?
We already had to charge the lady for a bad, I've had 3 fall through that place.
Yeah, 'cause I told you like, I have to because it's costing them so much money to even get a survey now. Sometimes I bill for it, the engineer bills them for it. And then we pay y'all to get it into this court over here. It's costing these people tremendous amount of money to even cut something out.
Yeah, I had 3, this lady trying to cut a piece off with pay her taxes.
Bob, is there a way around that? I thought you said there's exemptions for that.
Well, I think there is a way. I say, is there a way around it? I think the proper method is if you're going to subdivide land and you don't meet one of the exceptions, then you have to follow the subdivision rules. It's incumbent upon the divider to determine whether or not they fall within the statute. But the court, I don't think, ought to make it possible to sell a portion of land off by a lot owner without having some scrutiny. I think that's how we get into these situations of badly designed subdivision rules that don't cover the public interest, the public health and safety of, everybody involved. You say you've got a piece of land that's poorly drained, but you want to sell off that poorly drained part of the tract. to some innocent buyer, I just think you're asking for trouble by giving loopholes to anybody.
It says 2 or more. If you don't take that current track, it's one of the tracks, when you cut one out, that wouldn't be 2 or more. But if you're considering the remainder of that current track is another track, then the lady's gonna have to subdivide. I think you need to do it where you can, like Cobb counties, you can cut out one track, first track of the land. If you cut out anything else, then it goes into subdivision. They don't use that current track as 2 tracks.
Well, that's the whole reason why we discussed the tier system in the very beginning, is we're trying to do some small person, trying to do something a little here. More tracks or less is the number that got brought up. And that was the whole intention, was to make that very simple, very inexpensive, not involve engineering, everything else communicates just as the tidal wave is coming, it's just got.
And it's killing us. And it is killing us.
What happened is the poor rats,
Trying to do a planning, developers who come in and do it within subdivisions, when we were trying to do something small with a local lady that's trying to cut off pay taxes or whatever the situation might be. And then when we didn't, I don't know if you were there, we didn't discuss only doing 2 small tracks or, something small, and I don't know where the 4 came from.
But Dennis, that's what's killing us though. Now that's the developer's MO. They'll come in, not the little old widow lady you're talking about. I'm talking about the developer comes in and buys 10 acres and he does this one deal at a time. And that's what's killing us. They're not doing it the way they're supposed to do it.
Like I said, it's just, that the intention of what we were trying to do, I guess has gotten
And
off.
well, what happened is, you go underneath family. If you got a family, you can do 4 tracks in there.
No, that's always, that,
I know, but that's where it's been left at. It never, the very first meeting we had, we was trying to work something out. So it wasn't so expensive on these people that's trying to sell over 1 acre tract. And I'm from the old school, that ain't a subdivision, I don't care what anyone says. You sell a 1 acre tract off, that ain't a subdivision. That
No,
is.
it's not a subdivision, but it's a division of land.
Well,
The problem is, like, out on the 1652. That place has been cut up, and you saw how, the old Watson place, when we finished that in the estate, as soon as they sold it to somebody. They sold 1 lot, they built something on it, sold a lot, built something on it, sold a lot, built something on it, sold a lot. I mean, it's on Billy's place, and I'm looking at, there's 6 mobile homes and 4 houses that have been built in the last decade. Yeah, all it is place like driveways and.
They actually came through the subdivision policy on those lots. The ones that are on 16, 21, 30, 21. Okay.
But I know what you're talking about when it says, the exceptions do kill you when people know the rules and use it.
But to kind of put his point perspective on the 1 acre, I've had multiple times where people's come in and the parents have passed away. It's a single heir child. They've got 50 acres in a house. They want to sell the house. Well, you got to make them subdivide and cut the house out because they're selling it to non-family. What's the way around that?
If I come to you pre-screening, going to have to do a subdivision and ask for a variance. If you get that variance early on a situation that you're trying to really make exceptions for, is that not where you would do that? Can you not get the variance for that 1 acre house? I mean, why?
This is where I'm asking the lawyer, where's the land you at in that?
Well, I would say that the Commissioners Court has the ability to apply some discretion based on the facts of what's before you, instead of, talking about hypotheticals. We'll talk about this hypothetical. Say we've got 1 house, it's got utilities, we're just cutting an acre out and we want to sell the house. If I was advising the Commissioners Court, I'd say, well, it's a house, it's got all its utilities, it's got access. I don't see the benefit to the county to making this a one lot subdivision. That's just taking up a spot in the cabinet downstairs where we have flats. And if y'all require a bunch of one-track subdivisions, you're gonna need to buy more cabinets. Which maybe y'all can, and that's great, but I think that the rules as they stand allow the commissioners court some discretion in that case. But if it's what Mr. Bass suggested earlier, and somebody wants to sell, 2 acres of bottom land that never drains to some rube, you can say, hey, this doesn't pass the smell test, you've got to go through the whole process. But to Paul's point about getting to it early, if y'all can have that conversation before,
that's what I want, that pre-submittal conversation.
That makes sense.
And I've always said, you don't need a survey, just a sketch. If somebody bring a sketch in, so we'll know what's gonna happen.
Well, and if I come to Commissioner Melton on Monday for one, and I come to you on Tuesday with one, and I come to you.
Yeah.
Then you know that.
Then you know that
Yeah.
I'm trying to go through a loophole. And to be fair, you can't take.
We've done some variances, Commissioner.
I've done a ton of them.
Commissioner Pearson's come to this
I've brought it
court
to the
and
court.
asked for a variance, and we've agreed with him. And so that we can do that.
It's just exactly what you're talking about. It's existing house, it's all there. I come to the court and say, I allow this sale, the waive everything. They don't need to do all that stuff. They're just selling this existing house. They got 50 acres. The family selling the house, they're gonna keep the 49 acres. There's no need making them jump through those hoops.
Do our clients come in every time you have a board meeting, that we send all of our clients over here to y'all to sit out here to wait till you have your hearing?
I've done a lot of them. They were never here.
Okay, that's one man.
It'd be like any variance, you take that form and you want to cut this out, put it in drawing, submit it to your commissioner. If they want to meet, great. If not, you make it space. Look like it needs a variance.
We
That's
need
what
to,
I said, I think we should be very.
Look at
we do need a variance.
Right on what the request.
Yeah.
Bass, you got something?
Go ahead.
Look at section 1.3H. The owner does not lay out part of the tract as a street. There's access directly to a public road or a street. And the new part is to be retained by the owner. And the other part is to be transferred to a developer. The larger tract is still subject to the regulation, but you can let the owner keep one part. He conveys the rest to somebody else. That's of that transaction, that's exempt.
But that exemption only applies if the other tract is being developed. That's not what we've been talking about for the last 5 minutes.
This is already.
See, I thought that right there was going to cover us being able to cut out a 1 acre tract till you get on down there, then it says the developer's got to subdivide this 1 acre tract that we just sold.
Right.
Well, you can't even subdivide a 1 acre tract in this court, in this county, but that's what it says. And I thought that was gonna be the exemption that said, okay, if I got a 1 acre tract, and I'm gonna get to keep this one myself, and I'm gonna get to sell this one, but then all the garbage that comes after me selling it in the next clause abolishes
I think
what I thought the rule
I
was.
think you're missing developer. What Mr. Bass is saying, correct me if I'm wrong, Bob, is that person buying that to build that house on it, he is the developer. He may not be going to sell it to somebody else, but he's going to develop that piece of property. He's going to turn it into his homestead or whatever.
Ask him where
Or he
that
may
was
build a
at.
spec house on
Ask him where that was at. Oh, ask him where that was at. That's what I was gonna bring up. Cause I want to finish reading the rest of it to you. He got subdivided. That's what it says. It says he just can't build a house on it. He got subdivided.
Where does it say that?
Well,
The
that's what I'm trying to find where it is. in here.
last clause in paragraph 2. One new part is to be retained by the owner, the other new part is to be transferred to a developer who will further subdivide the tract subject to these regulations.
So that abolishes what I really thought it put in there for.
Right.
And you
Well-
can't about one extra track anyway.
If if you're gonna sell off 1 acre, one a month, one a year, you're finally gonna end up, if you use that exemption, you can, I just don't think that's the intent, if the owner can retain a part of the original tract and you can, leave the rest of it unaddressed, but if there's a buyer intending to develop that area, he's got to subdivide it according to the rule. Now, if the guy's gonna leave it in ag use, the 49 acres in ag use, and you sold off the house, that's okay. But if he starts subdividing that, then he's gonna have to follow the rule.
So what you're saying is if I keep it in ag, which I better have land adjacent to it, or I can't keep it in ag anyway if it's 1 acre.
It's gotta be 10 acres.
Yeah, so if I keep it in ag, because I have land adjacent to it, make the argument it's really 1 tract. And then I build a house on it 5 years from now, is that 1 acre developed as a subdivision, or is it still not under the requirement because it's not a subdivision because I didn't bust it into 2 half-acre tracts?
You can't go to the, I think we're missing the boat here on the size of it. If you sell 1 acre, it's done. It's not ever gonna be subdivided again. You can't, cause you can't go subdivide.
Yeah.
Now, if you sell a 2 acre tract, then you're a different deal. Then that guy could come in, the next guy could come in and subdivide that into 2 acres. But then he's gotta come back. I think what Bob's saying is
It's exempt until I take my 2 acres and break them into 2 1 acres. Then I got.
I think what he's saying is that you can, a guy that's gonna hold, the original owner is gonna hold X amount of land over here. He could sell that down to 1 acre and not have to do anything. If he sells more than that, then he could subdivide what he sells. But you're not going to, if you want to sell 1 acre, that will never be subdivided again because you can't go less than that. You can't get a septic system.
But then it doesn't fit the text of this exemption is
It's
Herman's.
not exempt because you can't do it.
Right.
This exemption only applies if it will be subdivided.
That's right.
That's right.
But with the knowledge that we're not in the city limits of, or we're not in Garden Valley where you do high acres, then so it would be assumed in Van County, I don't have to subdivide that because it's 1 acre. I don't have to plat it, I don't have to do anything.
Which would mean that
That's what I
exemption
feel.
would not apply
That's
because
right.
you can't
You
develop.
can't divide it.
But I'm gonna send up a flag if if that owner comes back and next time, 6 months from now, decides to sell another acre of land, I'm gonna say, hey, time out now. You're just subdividing 1 lot at a time, trying to get around our rules.
And that's happened and we've caught it.
Said the surveyor, what I tell them is, if you sold any land off, if they say, yeah, I said, well, sell any more off this thing, you gotta subdivide it, go find another survey.
That's right.
I'm not doing the survey.
Right.
That's what I tell them. And time I run the records, I know where they tell me the truth or answer, but I gotta run the records on this.
Okay, can we wind this up? Is there anything else that we need to tell Mr. Bass, or ask Mr. Bass? I think, have you got pretty much what we asked for, Mr. Bass?
Well, I think so. I guess let me do another review of the thing. I made notes as we've gone along. I think I've caught everything. I will send you a revised red line that, and then it's going to have to be read very carefully. You're going to have to go through it very carefully. if I could miss something, but yeah, I think I can give you that here in a fairly short period of time.
Was that fee schedule for those RVs you were talking about? Was that in there? Did you see that in there? Or is that something y'all did separately that he needs to get a copy of to put on that?
Right now, it's, the review fee is $500 and the rental space fees are $100 a piece.
So that's probably just need to be a total separate line for rental community properties on that things that we discussed.
Yeah, so there's a fee of $500 and it's $100 per space.
Thanks, Paul. Thanks, Mr. Director. Yeah,
All right, we ready to close the meeting
I
or?
think we're, Mr. Bass, do you have anything for us? Any questions?
No, I'll get in touch with you if I do.
Just send me the revised red line copy and I'll disperse it to all the committees.
Okay,
And,
I'll try to get that out in the next 10 days or so.
yeah, that'll be fine. I appreciate you very much.
All right.
Thank you, sir.
Thank
You
you.
bet.
Thank you.
All right, that concludes item number 3. Item number 4, discuss building codes and the motion to table, or do we vote workshop? Do we, or just want to table?
Table, I motion to table.
All right. All right, and then, adjourn,
Motion to adjourn.
we're adjourned at 12:30 p.m.
Thank you.
Thank you, gentlemen.
Boy, I really am sick of these subdivision rules and regulations. Mess with them for so long.
Complicated.
Yeah.
They're complicated.